Hi everyone, grab a drink and settle in. This is the Wheels and Spills podcast, where we sip cocktails and unpack the most fascinating state disputes behind the court judgments. The podcast is about real people, real disputes, and the wheels that have sparked them. To help me spill the story behind our next case, I have Reegan, Grayson, Morison. Reegan is a barrister who has a wealth of experience in trust and probate matters. She's appeared in matters including breach of trust and fiduciary duties, construction of trust deeds and wills, contested probate caveats, and judicial advice applications. In 2025, Reegan was recognised as the Doyle's Guide list of leading wills and estate litigation barristers. Welcome, Reegan.
Thank you.
So what case are we unpacking today?
Today we're looking at a case in the matter of the will of William Ian Southey. It's an application for judicial advice made by the legal personal representative of his estate.
Okay, so this is a unique case, and I want to provide a brief summary of the facts, and in particular, deceased relationships. So in 1976, the deceased was married to a woman named Kay, but separated 13 years later, but they remained close friends. The deceased was then in a relationship with a man called Philip. They were together for approximately 40 years until Philip died in 2017. After Philip's death, the deceased appeared to have been engaged in a few online relationships. The last relationship he had was with an American man named Kyle Jackson. I'll refer to him as Kyle. They formed a relationship from early 2022. The relationship was purely online. They'd never met in person. So throughout their relationship, there were no video calls and all communication was by email or phone. Despite this, the deceased made his will in contemplation of a possible marriage to him. Now, the deceased died on 11th October 2012 at the age of 73. In his will, he named Kyle as executor, and if he was unable and unwilling to continue to act, he appointed his ex-wife, friend Kay. I refer to her as the friend. He gifted his friend $100,000 in the will, and by clause 4 of the will, he gives the balance of his estate, which we refer to as the residuary, to Kyle. By clause 5 in his will, in the event that Kyle failed to survive him, he gives his residuary estate to his friend. Now, his estate was worth approximately $2.5 million. So after his death, the deceased former solicitor and his friend made various attempts to contact him. They had an email address for Kyle and a contact number. Initially, the person claiming to be Kyle said he was upset about the deceased's death and wanted nothing to do with the estate. Later, he changed his mind, demanding that he be kept informed of every step and to receive 15% of the estate's value. Now, there were numerous efforts made by the solicitors to verify his identity, but they came up short. They even engaged a private investigator to try and locate him, but were not successful. So the friend applied for a grant of probate of the will, and the court made orders passing over Kyle as executor, and the friend was granted probate on the 17th October 2023. The friend made an application to the court seeking judicial advice. Reegan, can you explain what is an application for judicial advice and what advice was the friend seeking from the court?
Sure. In Victoria, applications for judicial advice are made under Order 54 of the Supreme Court General Civil Procedure Rules 2025. Often, applications of this nature are made where there are questions that have arisen in the administration of the estate. In this particular case, the questions that had arisen regarded whether or not a beneficiary existed or just couldn't be found, and having regard to all of the circumstances of the case, how the estate should be distributed. That is, which was the applicable clause under which the deceased estate should be distributed. So it was a $2.5 million question, really.
So the friend submitted that Kyle did not exist and therefore the residue of the estate should be payable to her. She argued that in order for him to receive the gift, he needs to exist. As mentioned earlier, her solicitors tried to verify his identity using the contact information they had for him. They made requests for video calls but were ignored or refused. The person or person purporting to be Kyle refused to communicate other than by email. There was one such email sent by a person or persons purporting to be him, where they attached an image photo of a US passport in the name of Kyle Stewart Jackson, and it disclosed a residential address in Pennsylvania. So the solicitor sent mail to that address, but they received a phone call from the actual resident who said they never heard of him. Reegan, what was the court's view about this evidence and the attempts made to contact Kyle and verify his identity? And was the court satisfied that the person identified in Clause 4 of the will was Kyle and that it was the same Kyle that existed in the deceased's mind?
The court found in this particular case that the person named in Clause 4 of the will, that is Kyle Stewart Jackson, did not exist in the manner that the deceased understood him to exist, or at all. The reasons for that finding related to the evidence that was before the court, and specifically the image of the US passport that was provided in correspondence to the solicitors for the legal personal representative, Kay, was found to be that of a fraudulent passport. There were several reasons why the court made that finding, including that the passport photo didn't comply with the US Department of State requirements and other factors such as the period of validity, which seemed inconsistent with usual passports issued by the United States and likely other jurisdictions as well. The fact that the person had responded at the Pennsylvania address and said that no person of that name had ever resided at that location, to the best of their knowledge, was also relevant to the court's finding in that regard.
The friend also argued that in the event that Kyle did exist but cannot be found, then an order similar to a Benjamin order would be appropriate. Reegan, can you explain what is a Benjamin order and did the court think was appropriate in this case?
A Benjamin order is an order that the court can make which is a finding that a person is presumed to be dead so that an estate can be administered as if that person had already died. Applications of that nature are usually made where a beneficiary cannot be located despite exhaustive searches being undertaken by the legal personal representative or the trustee. In this case, the court found that it was unnecessary to consider whether or not an order of that nature should be made because of their finding that Kyle Stewart Jackson does not exist in the manner understood by the deceased.
So the court found there was no evidence that Kyle existed and therefore there was no valid beneficiary meeting the description in the will to receive the gift. So this meant the estate can be distributed without regard to the entitlement under Clause 4. So having determined the gift of the residue in Clause 4 of the will fails, the court must determine whether the gift over in Clause 5 operates or fails too. As mentioned earlier, Clause 5 states, in the event that my said partner, Kyle Stewart Jackson, fails to survive me, I give my residuary estate to my friend Kay Mosley for her own use and benefit absolutely. Now, Clause 5 is contingent on Kyle's failing to survive the deceased. Reegan, as we know, gift over clauses are very common in wills. You give the residue to a beneficiary, and in the event that beneficiary fails to survive, you give the residue to other beneficiaries. That could be your children, friends, charity, and so forth. It's usually straightforward. So if the person fails to survive, then it goes to the other beneficiaries. But in this case, it's a bit different. The question was whether fails to survive me could be interpreted to cover a situation where a beneficiary never existed at all. So the general rule or construction specific to a gift over clause is that a gift over on contingency will not usually take effect unless exact contingency has occurred. So if we apply this rule, in order for the friend to receive the residue, Kyle must have been alive and then died before the deceased. Now, as we know, there's always an exception, and there is an exception to this general rule, and this was referred to in this case. Reegan, can you please take us through the exception to the rule, and when does this exception get evoked?
In this particular case, the exception to the general rule was invoked because the court looked at the deceased's real intentions in making Clause 5 of his will. And that was the language of Clause 5 revealed a clear intention on his part to avoid an intestacy. Now, what that means is, in basic terms, is that he clearly wanted his friend to benefit if Kyle Stewart Jackson was not to benefit. And it is because of that that the court found that the estate should be distributed in accordance with Clause 5, and that is to his friend Kay Mosley.
So in concluding, the court advised as follows. The friend was entitled to distribute the estate without further regard for Carl, as the gift under Clause 4 of this will has failed. The friend is also entitled to distribute the residue of the estate to herself in accordance with Clause 5 of the will. This case went on for 2 years, and in the end, the person the deceased thought he loved never existed. We now live in a world of online dating, and this case is a reminder to take extra care before leaving your estate to someone you may not fully know. Now, Reegan, what are the key takeaways for you in this case?
Well, the key takeaways are to ensure that you know the identity of the people to whom you're giving gifts in your will. That obviously applies in a circumstance like this, where there was an online relationship and he was seeking to benefit someone that he'd clearly had very strong feelings for. But it also applies in other circumstances, for example, in respect of charities and other organisations to whom you may wish to leave gifts as well. Those are the scenarios that are more likely the subject of these sorts of applications, but no doubt there will be more cases like this in the future.
So don't get catfish, really, is what we're saying.
Exactly.
Thanks, Reegan.
No worries.
That's today's spill. Thanks for sipping along with us on Wills and Spills. Join us next time for another cocktail, another case, and another story worth unpacking. Cheers, Reegan.
Cheers.